Yet again, Paul Turner, the immigration barrister at Imperium Chambers. Something I wanted to talk about, which doesn't fall within Balagajari or TOEIC, but in general. Very recently I had a case in the upper tribunal whereupon some other counsel represented, and the issue I want to talk about is when is it appropriate not to call evidence by your witnesses, in particular in asylum or complex Article 8 cases. The problem and the reason why I'm talking to you about this is that I had a case where there was a voluminous amount of documentation that established on its face that the individual was at risk on return. The matter came before the first tier tribunal and was adjourned with directions that the Home Office ought to verify the documents. At the first hearing, the appellant turned up with a number of witnesses that would speak to the truth of his account. 6 months later, the matter came back before the first tier tribunal, and the Home Office, surprise, surprise, hadn't verified anything, hadn't done anything. Counsel took the view that they could win the case on a technicality, on the basis that the Secretary of State, by virtue of not following the directions and not verifying the documents, had therefore accepted the documents, and therefore the appeal ought to succeed on that basis, and did not call the appellant to give evidence, nor did he call any of the witnesses that attended for the second occasion to give evidence, even though they could speak to the documents and they could confirm the appellant's account. The first tier hearing determination, as far as I could see, concluded mainly of a squabble as to whether the appeal could win on such a small and narrow technical basis. The judge conscientiously considered both sides of the argument before rejecting the technical knockout blow, as it were, or the strikeout on behalf of the appellant, as it was referred to. Permission to appeal was sought from the upper tribunal and it was granted. And the matter came before the upper tribunal, and the upper tribunal's attitude initially was extremely hostile on the basis that it was the appellant was fixed with the counsel's behaviour, and counsel had chosen not to call the witnesses, and therefore the judge was entitled to disbelieve the appellant. The judge was particularly critical of the approach that was taken, and put the client in a very difficult position, because the client was all too willing to give evidence, as were the witnesses that had turned up. Fortunately, due to the amount of time that the judge had spent considering the various legal arguments, the judge hadn't actually considered all the documentation, and I was able to persuade the judge that the failure to consider the various witness statement evidence in support amounted to a material error of law, and that's led to the matter being reheard. The point about this particular talk is when is it appropriate for you not to call, if you're a representative or if you're a client and you're asked not to speak, when is it appropriate? Obviously there are certain times when it's just clearly not appropriate for someone to speak, such as if they have some significant mental incapacity or they're incapable of giving evidence. If that's the case, that must be supported by proper medical evidence rather than a mere doctor's letter that just says can't speak at court. There needs to be proper psychological or psychiatric evidence that explains why. Or it might be a case where there's a minor and it's just simply not appropriate for the minors to give evidence. Or alternatively, the case turns upon whether a document was or was not submitted with an application, and the mere reduction of the document will be enough for the appeal to succeed. But in asylum cases or complex Article 8 cases, in my experience, and it stretches back to the late 90s, when various people would run clever arguments or supposedly clever arguments and not call the clients to give evidence, in pretty much all the cases the judicial reviews or the appeals would be dismissed. And in my opinion, not unreasonably, because the whole purpose of the appeal process is for the judge to judge whether or not the person's telling the truth. And obviously, if they don't speak, then there's no ability for the Home Office to test the evidence. There's no ability for the judge to look and see the manner in which the evidence is given and how clear the answers are. And if I was a judge and somebody said, well, yes, I've got a pile of documents and this proves the case, so I'm not going to call my witness, I would be suspicious. I would think, well, why not? The individual speaks English, the individual's been here for a long time, the individual's given a statement, he's been interviewed, why doesn't he want to speak? And so obviously evidence and the weight to be attributed to evidence is a matter for the judge. So if you don't call the client to give evidence, then all the judge has is what's written down on paper. And that's a matter which is highly susceptible to the individual judge, and the judge may quite rightly place less weight on evidence which isn't backed up by oral testimony and tested in court. We do, after all, consist or operate an adversarial system where the individual is there are two opposing sides. There's the appellant and then there's the respondent, and the appeal is the opportunity, and it's a limited opportunity now, given the right of appeal being taken away so often, for an individual to actually speak and persuade a judge by their character, demeanour and the way they speak and the way they answer the questions, to persuade the judge that they are actually telling the truth. So if there is a moral, or if there is something taken from what I'm saying, it is that if you have a case, and even if you think it's compelling on paper, I would be very, very reluctant to advise a client not to speak, not to give evidence, and just to rely on the documentary evidence. As I say, there are exceptions, and they may be very valid exceptions, and I've won appeals without having to have the appellant give evidence. But in an asylum case or a complex Article 8 case where the judge wants to know, in essence, is the applicant or appellant telling the truth, or are there sufficiently compelling familial circumstances to engage Article 8 to the extent that the person should be allowed to stay, I would always make sure that the case is well prepared, make sure the client knows what to expect, and make sure that the client gets the chance to talk to the judge, because it is the judge that will decide as to whether the individual is telling the truth, not as to whether the barrister is super clever and has a wonderfully clever argument that's going to carry the day. Because in my experience, the judges are quite pragmatic, they're only human, and it's their job to discern whether or not an individual is, to the relevant standard of proof, telling the truth or not. So that's really pretty much the end of this unusual broadcast, given the fact that it doesn't mention Balagajari, TOEIC or the right to work. But and in those cases, I would obviously call the appellant to give evidence. I can't imagine a case where I wouldn't. I think I'd be doing my clients a grave disservice. So, in short, if you're considering whether or not to advise your client not to give evidence, think carefully about it. And if you're the client and that your counsel or your solicitor says don't give evidence, ask why. Perhaps even ask for it in writing, so that if it goes wrong, then you've got the basis to seek redress. This is perhaps a strange digression, but as I said, when I set up this channel, I would discuss matters that seemed important to me, and some of it will be case law and some of it will be actual practice or practicalities, or how to win appeals, or how not to lose appeals. I hope this has been of some interest. If you have an immigration problem or simply want to know more, please do not hesitate to contact me at Paul Turner at Imperium Chambers on 0207 242 3488, or at clarks@imperiumchambers.co.uk, or at my website, The Immigration Barrister. Thank you very much for watching. I hope it's been of some interest and of some use, even if it is a little controversial. This has been Paul Turner, The Immigration Barrister at Imperium Chambers.